Hi, class. No one showed up for today's Zoom. It's probably not that big of a issue in that I'm mostly going to lecture about important legalities of the First Amendment, important Supreme Court decisions, and other laws and that relate to writing for the mass media. Remember that next uh, if you have, I just sent an email to those who haven't submitted any articles. Um, should, I've already graded two for most people. The third one you should be working on now. Um, so don't find yourself uh, falling behind. Next week, we're going to have Jackie Spinner as a guest presenter. I believe she's going to join us at 1 because of her class that she teaches. Um, okay, so much of this, um, the final, which we have during finals week in May, will cover quite a bit of this material that I'm talking about today about the law and the First Amendment. And I sent you lots of links to the most important decisions for you to read. Um, we will review it in in our last class, either the end of April or the beginning of May. Uh, so there'll be another review on this for the final on the very specific things that are on the test. Um, what you need to know is to be sort of literate about the First Amendment. The two most important U.S. Supreme Court decisions are New York Times versus Sullivan on defamation and libel, which was a 1964 decision, and the other is the Pentagon Papers decision in the early 1970s, which said that the government can't stop the printing press of a news organization that is publishing national security secrets. Both have been the subject of very good, um, uh, well, I shouldn't say both, especially especially the Pentagon Papers case has been the subject of good TV, television and movie theater productions. And all the the movie, the fairly recent movie, The Post, uh, show, is a story of how the Washington Post was trying to catch up with the New York Times on the publication of the Pentagon Papers. Um, okay, let's start with New York Times versus Sullivan. Turn the time machine back to 1964. Um, it was when 1964 dawned. Um, there had just been the assassination of John F. Kennedy in Dallas, November 22nd of 1963. Kennedy had been trying to get a civil rights law passed unsuccessfully. Um, and at that time, the South was still segregated as a matter of law. So something that lawyers refer to as de jure segregation. The law required segregation, separate uh, separate eating facilities, separate restaurants, restrooms, drinking fountains, etc. Bus bus terminal facilities. Um, I remember as a kid growing up in St. Louis, which was a segregated city in 1964, that the, the restaurants downtown St. Louis were segregated. Uh, the St. Louis Hawks, which were an all-white basketball team that played the Boston Celtics and usually lost to them. The Celtics had a number of top black players, including Bill Russell. Um, and the Hawks would eat at the restaurant downtown called Miss Hulling's, a sort of fancy cafeteria. And Celtics were nowhere to be found because they couldn't eat there. So this is the beginning of 1964. Uh, that was the situation. Um, yeah, shortly before Kennedy was assassinated in the end of 63, in the summer of 63, was Martin Luther King's poor man's uh, March on Washington. And that's the famous civil rights demonstration in downtown Washington, D.C., where King gave his I Have a Dream speech. Uh, it's funny if he wasn't, King wasn't the first speaker, and a lot of the news accounts that were written at the time, uh, they were just sort of like running news accounts, and they just sort of got included King when the program reached that point, and you'd hardly know from some of the stories that were written that I Have a Dream speech is the only thing that anybody really remembers from that event, or the main thing. Um, so both Lyndon Johnson, who was the vice president at that time, and John F. Kennedy had pleaded with Martin Luther King not to rile things up with a civil rights march. It just shows how that kind of it was terrible advice. It required huge events like that to get things going. Um, uh, there had just in the previous year and a year or two of Kennedy's administration, James Meredith had required the National Guard to get him into the University of Mississippi. A former member of the Joint Chiefs of Staff, I think his name is Curtis LeMay, had led a bunch of rioters trying to keep him out, and had engaged in street fighting with the federal troops. Um, George Wallace, the governor of Alabama, had given a speech about segregation now, segregation forever, and he had literally stood in the door of the University of Alabama trying to bar black students um, when Nicholas Katzenbach, one of the top officials in the Department of Justice, came down to integrate it. Um, and I tell you about all of this. You might ask yourself, why is he talking about all the civil rights background, the New York Times versus Sullivan? And the reason is that New York Times versus Sullivan is very much of a product of this era of American history. Um, the people on their television screens were seeing all sorts of uh, TV news people who were showing uh, Southern police law enforcement officials uh, having dogs attack young civil rights demonstrators using powerful fire hoses to knock them off their feet, carrying them out of lunch counters where they were trying to get a hamburger and a Coke. Um, and um, and the Southern police and politicians were trying to shut down that kind of news coverage because it was turning most of America against the South and against the segregationists. And New York Times versus Sullivan was one of many efforts throughout the South to try to use libel laws uh, to break the bank at national publications like New York Times, Washington Post, um, CBS, all three of the networks, CBS, NBC, and ABC. Um, there were there had been the judgment in the New York Times versus Sullivan is $500,000 against the New York Times. There were millions of dollars of judgments throughout the South, and that's what the Supreme Court was concerned about. Martin Luther King was himself in the Supreme Court chamber for the argument, and as a matter of fact, one of the justices, I think it was Justice Goldberg, uh, sent down a copy of Martin Luther King's recently released autobiography to ask him to sign it uh, at the time of the court hearing. So the New York Times versus Sullivan decision um, involved, and this is important for this is one of the questions on your final. It involved not a news story but an ad. It was a full-page ad that had been purchased by black civil rights leaders and entertainment uh, people who are famous in the entertainment industry. There was a famous black entertainer by the name of Harry Belafonte, who was one of those who purchased the ad. I think Sidney Poitier was another. And the ad was, it was, the title of it was "Heed the Rising Voices." I print the ad in one of the academic articles I wrote about this. It's Sage NYT. And it said, "Heed the rising voices," which was reprinting a New York Times editorial saying people should pay attention to the civil rights movement. And but the ad had several mistakes in it, careless mistakes. And like, how many times had Martin Luther King been arrested by Southern officers and put in jail? I think I think the ad said 7 times, and I think the right number was 4. What was the patriotic song that the demonstrators sang at a protest? What was the did the police padlock the eating facility on a school campus? So sort of minor points, things that don't get fact checked in normal ads in magazines and newspapers. Um, and Sullivan was the head of public safety, and he sued, saying that he had been defamed. And even though his name was nowhere mentioned in the ad, um, the idea being try to make the New York Times pay money for making mistakes and discourage them from covering the civil rights movement. And this was, I mean, this wasn't just like a far-fetched legal theory. The New York Times at the time was not the was in financial problems. It just had a big labor strike, and the business side of the New York Times literally advocated that to the editorial side that they stop covering the civil rights movement because it was too big of a financial risk. I've used the word defamation and libel. So defamation means you write or say something that hurts, that attacks somebody's character and harms their reputation. If it's written, it's libel. If it's spoken, it's slander. Uh, uh, Twitter is considered to be libel. Libel. Sometimes people refer to it. And in the New York Times versus Sullivan, the decision was written by Justice Brennan, who was sort of the liberal spark plug of the court. This was the Earl Warren Court, the most liberal court in the history of the country. It was named after Earl Warren, the former governor of California, who in 1954 was named by Dwight Eisenhower to be Chief Justice. One of his first decisions was a unanimous decision of Brown versus Board of Education, desegregating American schools. Put in a little context, when I went to kindergarten, was the first year that there were nationally desegregated schools under Brown versus Board. So this was the liberal Warren Court, and in New York Times versus Sullivan, they said that it's not enough for a public official to prove that there were mistakes. There has to be proof of when the libel suit is filed by a public official, it has to be show actual. There has to be proof of actual malice. by which the court said they meant reckless disregard for the truth. So like if a news organization is writing a big investigative story on a public official and they don't call him up to get him or her up to get a comment, that would be reckless disregard for the truth. If they don't check out key facts in the story, that's reckless disregard for the truth. That's not carelessness. So the Supreme Court announced this. This was a constitutional revolution. Up to that point, libel and defamation laws were the province of the states. State law governed, and in most cases still governs defamation law. But this put a federal constitutional overlay on all libel cases in the country. They all libel cases in state or federal court had to abide by New York Times versus Sullivan. That's still the case, and it has been a controversial decision for many years. Just recently, justices, I believe it was Gorsuch and Thomas, said that the Supreme Court should reconsider the libel case, the libel decision, New York Times versus Sullivan, make it easier to win, for public officials to win libel cases. Donald Trump has used defamation cases to pretty successfully in the last several months. He filed a libel case against George Stephanopoulos and ABC for having reported that a court in New York State had found that he had raped a woman, and a sort of noted author in a department store in New York City. They had found that the jury had found that he had assaulted her and that he had digitally penetrated her in a dressing room of this big department store. And the judge had said that amounted to rape. But Trump filed a six-figure defamation case that the ABC, once he became president, was intimidated enough to make a payout on. So the New York Times standard was not too hard for Trump to be able to succeed in a case where he couldn't. There's no way he could have succeeded in a court of law, in my opinion. Also, there have been some big defamations sort of on the other side of the political aisle. Two women who were poll workers, election poll workers in Georgia during the 2020 election, were accused by Trump and Rudy Giuliani and some right-wing news organizations like the Gateway Pundit of having stuffed ballot boxes, and that was proven to be untrue, and Giuliani had to pay a large settlement. Also, Fox News reported that Dominion Voting, that was in charge of the voting machines in Georgia, had been controlled by communists and had substituted Biden votes for Trump votes. All that was proven not to be true, and Fox News had to pay a little short of $1 billion in a defamation case that Dominion Voting filed against them. So so libel defamation is a top of the mind issue today, even though it's many years after New York Times versus Sullivan. Let me jump forward about 6 years, oh, let me just close the loop on the civil rights history of 1964. After, so the Supreme Court issues New York Times versus Sullivan that summer. The Senate finally overcomes a filibuster and passes the Civil Rights Act of 1964, making it illegal to discriminate based on race, sex, national origin, etc. Um, an interesting side note is that a member of Congress from the South added sex into the prohibition of in the statute's language, add sex discrimination in, thinking that it would be a poison pill because no Congress would ever pass anything to bar sex discrimination, and he proved short-sighted on that. Okay, so now New York Times, Pentagon Papers case, which is uh, New York Times versus the United States. Um, uh, Daniel Ellsberg was worked for the government in the Defense Department of Robert McNamara, the defense secretary that Kennedy had appointed and who was running the Vietnam War. Daniel Ellsberg was assigned by McNamara to write a history of the Vietnam War, so that so the decision makers in the future would know what had led policymakers down to various decisions. And Ellsberg came to realize that the U.S. was not winning the Vietnam War, and in fact was losing ground to the Viet Cong and the North Vietnamese Army, and at the loss of tens of thousands of U.S. troops. The death toll was in the 50,000 range of U.S. troops and millions in Vietnamese civilians and guerrillas and troops who were killed. So Ellsberg puts together this 40-plus volume. He and others put together this 40-plus volume of a history of the Vietnam War and U.S. involvement that dated back all the way to when Harry Truman got the U.S. involved at the time, and Dwight Eisenhower at the time of Dien Bien Phu, which was the big battle where the Viet Cong surrounded the French army and won independence from France, which had owned Vietnam up to that point. Ho Chi Minh became the president and was the most popular person in all of Vietnam, but the U.S. Favored dividing Vietnam into two parts so that the communists couldn't take over the entirety of Vietnam, and Saigon became now Ho Chi Minh City. Saigon became the capital of South Vietnam. There were huge demonstrations on college campuses during this period of time. Students were killed by the Ohio National Guard. 4 students were killed by the Ohio National Guard during a protest at Kent State University in Ohio. A number of protesters at Jackson State in Mississippi, black protesters, were killed during this period of time. There were huge marches on Washington, much bigger than the '63 civil rights demonstration that I just described to you. So Ellsberg, in 1971, I sort of know these dates pretty well because the day I graduated from college was the day the New York Times published Daniel Ellsberg's Secret History of the Vietnam War, the Pentagon Papers. And President Nixon and his administration went to, and what it primarily showed is that presidents from all through U.S. history, and particularly Kennedy, Johnson, and Nixon had lied to the American people, and in saying in not recognizing that uh, that but for U.S. intervention, that Vietnam would be a single country under Ho Chi Minh's leadership, and also in claiming that the U.S. was winning the war. Um, and so the Pentagon Papers were released. Nixon and his lawyers went to a court and won an injunction halting publication. And it was so that they obtained an emergency order, and one of the emergency orders is called an injunction, a preliminary injunction, that told the New York Times they had to stop the presses. So the New York Times had printed one day, maybe 2 days, I'm not sure, and the presses were stopped. The Post is a story of how the Washington Post, which was sort of in the shadow of the New York Times at that point, um, and still is really, wanted to catch up on the story, and they ended up getting a copy of the New York of the Pentagon Papers and published them as well a week later. The case went up very fast, and the Supreme Court considered this case on an expedited basis, and they ruled that an injunction like that was an unconstitutional prior restraint on free speech and violated the First Amendment, and that the publication could go forward. I mean, it wasn't the because it was considered so fast by the Supreme Court. You have to sort of like count up the votes to see what do 5 justices agree on, and actually 6 justices agreed that it was an unconstitutional prior restraint. The most important opinion was written by Potter Stewart. It's really a worthwhile opinion to read, and he said that the press was a constitutional check on abuse by the other branches of government. We sometimes talk about the checks and balances between the legislative, executive, and judicial branches of government that are written into Article 1, Article 2, and Article 3 of the Constitution. Well, the First Amendment is a check, particularly in situations like the one that existed then, where you have Congress and the White House controlled by the same party. I mean, it's really a little bit like situation we had now. But then it was Democrats, and now we have Republicans. And the Democrats were not providing any kind of a robust check on Lyndon Johnson's conduct of the Vietnam War. As a matter of fact, one of the things that the Pentagon Papers showed was that the so-called Gulf of Tonkin incident, which was used as the legal basis for the U.S. escalation of bombing of North Vietnam and bombing of Hanoi by B-52s, that the Gulf of Tonkin incident was misreported by Johnson to get Congress to pass the Gulf of Tonkin resolution ordering any kind of response, a military response. What the Gulf of Tonkin incident was it was the claim by the United States that North Vietnamese patrol boats had fired on a U.S. ship. And in fact, it turns out it was sort of, it didn't happen. One of those fog of war situations that was misreported. Yet it was the basis for the next 10 years for the war in Vietnam, killing 50,000 plus American men and some women as well, who were, people forget that there were a lot of women on the front lines of Vietnam as nurses. Okay, so the Supreme Court says this is an unconstitutional prior restraint. The prior restraint of the press is about one of the strongest First Amendment rights that exists. One of the reasons it's so strong is it dates back to the day of the writing of the First Amendment in the late 1700s, 1791. Um, there was a famous, English legal commentary author. His name was William Blackstone. Wrote the Blackstone Commentaries, and they are often pointed to as being the the best source of what the state of Anglo-American law was at the time the Constitution was written. And Blackstone specifically said that prior restraint, that the government couldn't restrain publication, even if they could punish someone afterwards. Um, and quite honestly, although the press doesn't talk about this very often, uh, and our two First Amendment lawyers talk about it very often. Two of the justices in the Pentagon Papers decision, Stewart and White, who were needed for the majority, said that they would have no problem if the government were to file espionage charges against the New York Times and Washington Post for publishing those documents. Fortunately, the whole thing was sort of was such a defeat for the Nixon administration that they did not pursue that. Couple of footnotes. So when the story first was reported, Ellsberg was a confidential source. He at first hoped he'd be able to stay out of it because a government official leaking classified information is clearly violating the law. A news organization that receives that leak and publishes it is in general not violating the law. Only one self-described news person, and that's Julian Assange, has ever been prosecuted and eventually pled guilty to violating the Espionage Act. And Julian Assange, there's an argument we could have for a long time on whether Julian Assange of WikiLeaks fame is actually a publisher in the sense of the First Amendment or not. Julian Assange came back into the headlines in the 2016 election when he became the source, although he denied it, of material that had been hacked out of the Democratic National Committee emails and Hillary Clinton emails that were important in the 2016 presidential election campaign. So he was actually acting as in that situation as an agent for Russian intelligence that had hacked those emails out of the Democratic Party computers. So is he a journalist? I don't know. I used to think so. I'm not so sure I do anymore. Once a person becomes an actual agent, works hand in hand with agents of a foreign power, and in this case, the foreign power that had the greatest is oftentimes an enemy of the United States. I have to question whether they're actually a journalist with First Amendment protection. But like I say, debatable. So eventually though, Ellsberg's name did become known and was disclosed. And when I say eventually, in short order, by the time the case was before the U.S. Supreme Court, Ellsberg, it was known that Ellsberg was the source, and he was prosecuted for violating the Espionage Act. The Espionage Act was passed in 1917 and 1918, period of time during World War I, the time of great national fear, and it makes it illegal to help an enemy of the United States. And it's very broadly written, and so courts have tried to narrow it in interpreting it so as not to violate the First Amendment. But Ellsberg was prosecuted, but his case was thrown out because of a subsequent development, which was the Watergate scandal. A year later, um, or actually right about the time, um, well, in the summer of 1972, so it was a year later, um, um, burglars paid by President Nixon's campaign funds broke into the Watergate Hotel to try to get political espionage that would help Nixon get reelected. And they were paid for by Nixon campaign funds. They were caught and they were prosecuted. Woodward and Bernstein were Bob Woodward and Carl Bernstein were two Washington Post reporters who followed up on the story. They won a Pulitzer Prize for the Washington Post, and their stories led to a suspicious federal judge putting a lot of pressure on the Watergate defendants, who then provided the proof that they'd been paid by the White House. And it turned out, to everyone's surprise, that Nixon had been taping all of the conversations in the White House. And so a special counsel subpoenaed them. Nixon said he wouldn't turn them over, went to the Supreme Court. The Supreme Court said he had to turn them over because it was a criminal investigation. And the tape showed he was paying for the lawyers to defend the burglars, because his campaign money had been used by the burglars to pay for the burglary. This gets us though to the whole question of confidential sources, which is an important question issue for people who write for the mass media to know about. In general, I mean, it's much better for your stories to be based upon, in a perfect world, to be based upon real people who are willing to say things and stand behind them, and be quoted in your stories. And you should always strive for that. I'm sure some of you have seen where I've said in your stories, why is this person seeking anonymity? I mean, a person writing about that has to put pressure on the individual um, uh, to use their name or explain why they don't want to, or why they're too afraid to. Sometimes that might be, well, they think they'll get fired. Um, um, and sometimes they're right about that. So for that reason, confidential sources are really, even though they are to be used as a last resort, they are an important last resort. And as you all know, I spent 12 years covering Washington, D.C. And in that period of time, it became very clear to me how important confidential sources were. Because nobody in Washington wants to say anything that's going to get them fired or get them in trouble with their boss. So I would start almost every conversation with a congressional aide or a lawyer in the Justice Department, on the basis of, let's just talk on background, off the record. And so confidentiality is very important. Well, a case came to the U.S. Supreme Court in this early 70s period of time called Branzburg versus Hayes. It involved three different reporters. One was the person named in the case, Branzburg, who was a reporter for the Louisville Courier-Journal, who had witnessed people using drugs, and they had photos of people using drugs. And a prosecutor wanted to get their information to prosecute the people who were using drugs. Many people referred to this case as the Earl Caldwell case, because Earl Caldwell was another case that was combined in the Supreme Court decision. Earl Caldwell was one of the first, maybe the first, black reporter for the New York Times. He was a witness to the assassination in 1968 of Martin Luther King. After that period of time, he was covering the Black Panthers in San Francisco. Another good movie is the Chicago, I can't remember the movies, the Chicago 7 or the Chicago 8. It's a movie about the prosecution of Black Panthers and anti-war students for Democratic Society radicals, whether underground, in the period of time after the 1968 Democratic National Convention in Chicago. And so Black Panthers people were always referred to as a militant Black Power organization. I mean, they'd walk around with guns and rifles. A number of the Black Panthers went to prison. Huey Newton was one who went to prison and then came out and was sort of a celebrity. Bobby Seale was another. Earl Caldwell, the New York Times reporter, was spending his time interviewing Black Panthers in Oakland, across the bay from San Francisco, and heard them talking about, and wrote up a story on them talking about having illegal guns. He'd actually seen the illegal guns, and planning to assassinate the president. The U.S. attorney subpoenaed Earl Caldwell to come and testify before a grand jury. The New York Times said that this is protected by the First Amendment. The case went to the Supreme Court along with the Louisville Courier-Journal case. And there was a third case involving the Panthers and a broadcast reporter whose name was Pappas. And the Supreme Court ruled with Justice Byron White writing the opinion that the First Amendment does not protect the confidential relationship between a reporter and a source in the same way that the law protects lawyer-client or priest-penitent or doctor-patient relationships, that there's not a similar protection for lawyer, for reporter-source relationships. It was a 5-4 decision, and one of the justices in the majority, Justice Powell, wrote sort of a complicated concurrence saying that while he agreed with Justice White that if a prosecutor was acting in bad faith, that then there might be First Amendment protection for a journalist. When I say operating in bad faith, meaning sort of using a grand jury in an abusive way to try to put pressure on a reporter to disclose his or her sources. At any rate, New York Times, Branzburg versus Hayes is still good law. The Supreme Court has reaffirmed it. There's not First Amendment protection for a journalist source relationship. However, all the states, but the District of Columbia and all states except for one, I think Wyoming, that might be Montana, except for one, has passed what's called a shield law. The shield laws in state court provide some sort of legal protection for a reporter to protect the name of a confidential source. And most of the laws require prosecutors to first try to get the information on their own. There is no federal shield law. One of the reasons there's no federal shield law is because of people like Julian Assange. The Congress never wants to protect somebody like Julian Assange. who, like an activist who is is playing a political role, or sometimes even an enemy intelligence role. So there's no federal shield law. So this a reporter seeking to protect a relationship with a confidential source can only do that in state court, not in federal court. Um, okay. So those are two of the most important decisions for you to know. New York Times versus Sullivan on defamation, New York Times versus the United States um, on Pentagon Papers. I want to touch on a couple other things. The Section 230 of the Communications Decency Act. That is not part of the Constitution. It is a law passed by Congress in 1996 as part of the Telecommunications Act that was passed in order to sort of protect the growth of the internet, which was beginning to burgeon at that time. And what it basically says is that the social media companies, which are now, of course, giant, powerful forces, but weren't back then, the social media companies like Facebook and Snapchat and Instagram and TikTok, etc., they cannot be sued for some illegal content that is posted by a third party. They're not responsible for third party content. So if a poster says defames a public official or a private individual, the poster can be sued, but the social media outlet cannot be. There is quite a bit of controversy. There was a Missouri and Louisiana filed a Supreme Court case, a Supreme Court suit last year, saying that the social media giants, when they refused to publish President Trump's false claims about the 2020 election, or the false anti-vaccine, anti-COVID claims of right-wingers, who were saying stuff like you can use bleach to try to get rid of COVID, that kind of dangerous stuff, that when social media companies took down that kind of false enough and dangerous information, that they were violating the First Amendment. The Supreme Court ruled this past year that that was not the case, that social media companies can make a decision that particular posts should be taken down because they're hate speech or because they're false and dangerous, and that's part of their First Amendment right to edit their platforms. Again, the election of Trump has, to a certain extent, changed the environment, because the social media companies, in order to cozy up to the president, have changed the way in which they monitor postings on their websites, and now they are allowing much more dodgy posts to be left up on their platforms. I mean, Elon Musk is a perfect example. Many of Elon Musk's posts are false, yet he is the owner of one of the most influential social media platforms, and he's the most followed of anybody on his own social media platform. So he pretty much can say anything he wants, true or false. He can make up all these stories about 200-year-old Social Security recipients, and the Clinton wedding of getting all sorts of millions of dollars of USAID money, all this stuff being false, but nevertheless, he can just put it up there because he's pretty untouchable. Although I would think that Chelsea Clinton might well have a kind of a lawsuit against a rich guy like Elon Musk. He is responsible for his own posts, even though X is not under Section 230 of the Communications Decency Act. So Congress can amend the Communications Decency Act and might do something like that. We'll see. Also, I want to say you need to know the other sort of like main topic of this lecture is copyright and plagiarism. Copyright and plagiarism aren't the same thing. They're both using somebody else's words improperly, but copyright is a law. Plagiarism is like a professional code of conduct. Students and professors and journalists can lose their jobs or be kicked out of school by stealing somebody else's words and passing them off as their own. In copyright, if you use words that are copyrighted, you can be sued for money damages. There are a number of copyright cases that I have put in the reading. One of them involves Two Live Crew's spoof of the Roy Orbison Pretty Woman ballad. They made a big hairy woman spoof, a parody of that. And the Supreme Court ruled that parody has more protection, and that was they didn't violate Roy Orbison's copyright of Pretty Woman in putting out that parody. Another one of the copyright cases is one of the key issues in copyright is have you used too much of a copyrighted work? There's an exception to copyright called fair use, and it allows in some cases for small parts of a copyrighted work to be used. The Nation, which was a left-wing paper, got a copy of Gerald Ford's autobiography that he was writing for Time magazine, Time or Life magazine, McGraw-Hill, and they published a portion of the Ford memoir that said why he had pardoned Richard Nixon after Watergate. And the Supreme Court said, the Nation claims, well, this was news that somebody gave us over the transom. And so the news exception to copyright should allow us to publish it. And the Supreme Court said, no, you used too much of the work. You used like 400 words. That's too much. And it was the only thing anybody cared about in the Ford memoir anyway. So because it was the most important segment of the copyrighted work, and you used too much of it, that the Nation had to pay McGraw-Hill for the copyright infringement. There's one other copyright case that involves a statue that a homeless organization in New York, in Washington D.C. had a sculpture create for them, and the sculptor thought he should have the intellectual property rights to the sculpture. The homeless organization thought it should. The Supreme Court said, well, because the sculptor was working as an independent contractor, not as an employee of the nonprofit, he got to have the sculptor got to have the copyright to it. So independent contractors are able to hang on uh, to the copyright to their work. You can't copyright the phone book. You can't copyright a recipe. You can't copyright a theory. You can't copyright the theory of relativity, although you could copyright a book. Einstein could copyright the book in which he wrote the theory of relativity. Some of those, a person can't copyright a picture taken by a monkey, nor can anyone collect copyright for the selfie the monkey took. That was an actual case that I've got in the readings. There's a case involving Prince, and I think it was Purple Rain is playing in the background of a video a mom takes of her kid pushing a plastic shopping cart around an island in a kitchen. And Prince tried to sue for copyright infringement. He had a lot of people who were trying to enforce his copyright, and um, the court said that there wasn't that was a fair use that the mom had made of one of her videos. You can't if you're putting together something for publication on the internet in any form, even if it's just like an internet dossier of your work, portfolio, I should say, portfolio of your work. You can't just like take a nice picture off the internet and use it for your purposes, for your portfolio. Even if you give credit to the source of the photo, giving or the words, giving credit is not enough. You have to get permission. If you get permission or pay for the copyright, then you can use it. The rules for educational portfolios, I've got a whole readout. It's called Port Rules, Portrules. That's attached to one of the announcements that says that you can use more. The copyright rules are relaxed for educational portfolios that aren't on the internet. So like, when you're submitting, say, a story to me for this class, and you grab a photo from the internet, I'll remind you of what the rules are, but you're grabbing it and submitting it to me as part of your project is not going to get you sued for copyright. Okay, I think that's the most of it. So get your second stories in if you haven't. Get started on your third stories. Remember, the fourth has got to be longer and involve more research and more more interviews and all. And Jackie Spinner will be our guest speaker next week. All right. See you next week. Bye.